What are the limits of ICC jurisdiction? Imagine a court that can hold individuals accountable for the worst crimes in the world. Now picture that court with boundaries that sometimes keep it from acting. That's what we're exploring today. The International Criminal Court, or ICC, was created to prosecute serious crimes like genocide, crimes against humanity, war crimes, and the crime of aggression. It's based in The Hague, Netherlands, and works under the rules set by the Rome Statute. But it doesn't have unlimited power. Its jurisdiction has clear limits that shape how it can enforce international humanitarian law. First, the ICC can only prosecute for types of crimes. These are genocide, which means trying to wipe out a group, crimes against humanity like mass torture or sexual violence, war crimes such as attacking civilians or using banned weapons, and the crime of aggression, which involves using force against another country. The court focuses on individuals, not countries or governments. So, leaders or soldiers can be held responsible, but the state itself cannot. Next, the ICC's jurisdiction depends on where and when the crimes happen. It can act if the crime occurs in a country that has signed the Rome Statute. It can also prosecute a national of such a country, even if the crime happens elsewhere. But if a crime takes place in a country that has not joined the Rome Statute, the ICC usually can't step in. The only exception is if the United Nations Security Council refers the case, which is a special process that allows the court to act outside its usual limits. This is a major restriction because many conflicts happen in countries outside the court's reach. The court can only look into crimes committed after July 1, 2002, when the Rome Statute officially started. Crimes before that date are outside its jurisdiction. Also, even if the court has the authority, it will only act if national courts are unable or unwilling to investigate or prosecute the crimes. This principle, called complementarity, means the ICC is a court of last resort. It steps in only when domestic systems fail to deliver justice. In practice, these limits mean that many serious violations might go unpunished. For example, if a military commander orders attacks on civilians in an ICC member country, the court could potentially prosecute. But if the same acts happen in a non-member country, the ICC might not be able to act unless the Security Council intervenes. The court also depends heavily on countries cooperating by arresting suspects and sharing evidence. Without this cooperation, even clear cases can stall. The crime of aggression adds another layer of limits. The ICC can only prosecute it if both the country accused of aggression and the victim country accept the court's jurisdiction. These rules only came into effect in 2018, making it even harder to hold states accountable for acts of war. All these limits affect how well the ICC can protect civilians and enforce international humanitarian law. Many violations in conflicts outside the court's jurisdiction or in powerful countries might not be prosecuted. This creates gaps in accountability, even though the ICC is a vital tool for justice. Its focus on individual responsibility aims to deter future crimes and uphold the rules set out in the Geneva Conventions and other treaties. But the reality is that political and legal barriers often restrict what the court can do. Understanding these boundaries helps us see both the strengths and the challenges of international justice today.